Hello, I'm David Cann. Today I'm going to read out a script written by Alan, a British father of a son and daughter. He wanted to tell you his story in person, but if he did so, he'd be in breach of a court order, as his children could be identified. Instead, I'll read out his story. I was arrested on board an aeroplane after arriving at Heathrow Airport following a business trip overseas, and marched off the plane in full view of the other passengers by two armed police officers. I was sure they must have mistaken me for a terrorist and thought all would be cleared up once they realised their mistake. However, once I got off the plane, I was informed that my wife had made an allegation against me. They wouldn't tell me what the allegation was. I didn't know it at the time, but my wife had initiated divorce proceedings while I was away. She'd walked into a police station and made an allegation of common assault against me. She changed the locks to the doors on our house and removed my name from a shared bank account. She'd insisted the police not let me back into our home and that I not see the children. I later discovered that the London Metropolitan Police Service, the MPS, had lied in their report in order to have me arrested, inflating the allegation from common assault to serious assault. They exaggerated their risk assessment of me as medium risk on the basis of possible addiction to painkillers, because I take ibuprofen and paracetamol for migraine headaches, ticking yes to the question, do they isolate you from support or help? My wife wrote, he's tried to stop us from going to my church. I had expressed an interest in changing churches. They ticked yes to a question about controlling behaviour, writing, he's very controlling. No further details. Even with the police's highly exaggerated case, it still didn't make sense to arrest me on board a plane in full view of the other passengers. I wasn't a flight risk, and I was flying into the country, not out of it. At Heathrow police station, they took my photo, a mouth swab for DNA, my mobile phone number, my mobile phone's ICMI number, my fingerprints, and all my belongings. Then they locked me up in a cell. At about midnight, they decided to transfer me to my local police station by putting me in the caged partition of a police van and driving for 2 hours to the station where my wife had walked in to make the allegation. At the 23rd hour of my detention, I was interviewed by a young police officer who said he was part of the Community Safety Unit, the CSU. I explained the home situation. I told him my wife was overprotective of the children, not wanting me to take our daughter to trips abroad, including visits to my parents, and we had disagreed about this. It was an ongoing issue that we need to deal with through individual counselling or marriage counselling. I was concerned for her mental health. I thought I would be free to go. I was very wrong. My Kafkaesque nightmare was just beginning. The Community Safety Unit, I later learned, used to be called the Domestic Violence Unit. It's a specialist unit that arrests people accused of domestic violence or hate crimes. The MPS Police Commissioner has publicly stated that it is their policy to always believe the victim, who is almost always a woman. This policy is set out in the MPS Domestic Abuse Plan 2014 and the Crown Prosecution Service's Victim-Centred Protocols and Procedures. They sound benign until you realise that they involve men being treated as guilty until proven innocent and being stripped of their rights from the minute that a woman makes an accusation against them, regardless of merit, evidence, or severity. The policy states, where an offence has been committed, officers must arrest the suspect. What constitutes an offence? Any allegation a woman makes against a man. What constitutes evidence? A woman's word. Why must the suspect be arrested if it's unnecessary? Who knows? In other words, if any woman calls the police, then the man will get arrested, or else the police will owe an explanation to the Home Office, which they would rather not give. It's that simple. This policy, which is unique to cases of domestic abuse, is not applicable to other crimes, such as suspected murder or robbery. It is inconsistent with the Human Rights Act. The policy compels unlawful and unnecessary arrests and inflicts draconian bail conditions on male partners until their innocence is proven. The draconian bail conditions result in innocent men becoming homeless, emotionally broken because they can't see their children, and financially broken because they must pay solicitors to fight for their innocence. They will often become unemployable if a false criminal conviction results, or even if no conviction results. The policy was designed by feminists so that one phone call by a woman to the police leads automatically to an atom bomb being dropped on the man and the family. The attack cannot be called off by the woman if she has a change of heart. I know because my wife had a change of heart, but was unable, much to her own regret, to reverse the process that she had set into motion and which went far beyond her control or mine. The CSU, police and CPS prey on vulnerable women and weak families, exploiting any low point in life to break up families and to get arrest and conviction numbers up. Who can blame them? This is how the Home Office incentivized them. This is the basis for their evaluation and the means to promotion. The police want arrests. The CPS want convictions. The CSU, police and the CPS have been incentivized to destroy lives and families by engaging in witch hunts to criminalize men and boys over 16. As a separate unit, the CSU doesn't deal with issues that might keep them grounded and give them perspective, such as homicide, burglary, fatal car crashes or stabbings. They live in a world where they're trained to see normal people, good fathers and good men, as abusers. They receive regular training visits from private anti-male special interest groups such as the Women's Aid, Refuge and the National Centre for Domestic Violence, the NCDV. The funding of these special interest groups depends on the police making more arrests. After the interview, the police released me 7 minutes before the 24th hour of being arrested and detained. They hadn't charged me with anything, but put 2 bail conditions on me. 1, I wasn't allowed to go back to my home. 2, I wasn't allowed to contact my wife. I was instantly made homeless and would spend the next 2 months sleeping on the floor of my office. I would eventually have to rent a flat for a year that cost me £20,000, in addition to what I was already paying on my home mortgage. My wife's parents lived at a house 10 minutes away from ours, so I asked the officer why I was being kicked out of my own house. If my wife genuinely thought I was a danger to her, then she could stay at her parents' house. They didn't explain that they refused my request that she stay at my parents' house. The police bail conditions also instantly blocked me from seeing my children. This forced me to incur £35,000 in legal fees over the several months, fighting to see them through the family court system. My wife spent nothing on legal fees. 2 weeks after my arrest was my son's birthday. I decided to go for a jog in the neighbourhood past my house. It was a Saturday and I discovered that my son was having his party in the back garden. I could see his friends entering the garden through the fence. I slowed down and walked past. I could hear my son playing, but I couldn't see him. 3 weeks after my arrest, I asked the headmaster of my children's school if I could arrange a regular time each week to have lunch with my children. He initially said yes, but then the school contacted their designated social worker contact at the local council and was advised not to let me see them. This was totally unlawful, but I complied. For the 2 months following my arrest, I had to get friends to call my house and ask the phone to be passed to my children. My parents called the house with me on a conference call. My daughter answered, and my parents and I spoke with her initially. Then, when we asked to speak to my son, she said, "He doesn't want to speak to you." We then heard my son clearly say, "No, wait, I do want to speak to Daddy. What are you saying?" We then heard my wife whisper something. We didn't hear my son speak, and the call was cut off. The police then instructed my wife that she shouldn't let my parents speak with the children when they called, even though no allegations were ever made concerning my parents. I've never cheated on my wife. However, 6 weeks after my arrest, I was told by a close mutual friend that my wife believed I was cheating on her with a particular acquaintance. Hell hath no fury like a woman scorned. I asked this acquaintance, a long-time university friend who is a wife, mother and senior civil servant, to call our priest and attest to him that she and I have never had an affair and to communicate this to my wife. The police had ghost-written my wife's witness statement and asked her to sign it. It included many buzzwords and key phrases like controlling and had been happening for a long time and hadn't reported it before because no one would believe me. I immediately knew when I read the statement that these were not the words of my wife. Her interview was conveniently not video recorded, unlike mine, and there were many words and phrases in her witness statement that were not in her working vocabulary. Several months later, I met another father in a similar situation who was dealing with the same police station. We showed each other our wives' witness statements. They were uncannily similar and had the same buzzwords. The CPS and Women's Aid had trained the police well on how to write witness statements for women to sign. The police have targets to meet for domestic violence arrests. According to a former police officer under Bernard Hogan-Howe, the London Metropolitan Police Commissioner, the Met had a senior officer with a reputation as the Commissioner's witchfinder general, touring police stations and berating borough commanders for not achieving targets. Who sets these targets? They must have come from the top. The police forces reported to the Home Office. The Home Office was headed by Theresa May from 2010 to 2016. After being locked up for 24 hours and released on bail conditions, I was allowed to go back to my house for 2 hours to pick up some belongings. I was told that my wife wouldn't be there, but my mother-in-law would be present with the keys to open the house. The keys to my house that I owned and had paid for. Once I got there, I asked my mother-in-law what the hell was going on. This is when I first learned that my wife had initiated divorce proceedings. As it turns out, my wife had suffered an anxiety-induced breakdown. She was taking care of our very active children, was sleep-deprived, working part-time and taking a course for career progression. We'd been arguing a lot, mostly over differing opinions about what constituted safe activities for our children. I was an adventurous man, wanted to show the children the world. She had become a typical higher anxiety modern mum, wanted to protect the children from every conceivable danger in the world. She wouldn't let me take the children camping in our back garden for fear of foxes eating them. She once drove around our town looking for me in a panic when my son and I were 20 minutes late coming home from a haircut. She became paranoid that I was going to abandon her and take the children. For years, she hid the children's passports from me. Such anxiety like this in women has become a very serious problem in modern society, much of it caused by the sensationalist tabloid press, government fear-mongering, and state-funded women's groups. What I believe pushed my wife over the edge was an argument right before I left for my trip about taking my daughter to Madrid to see my parents. There was no assault, but there certainly was an argument, which isn't illegal yet. My wife had been certain that I or my parents would let go of my daughter's hand in Madrid and that she would go running off into the crowd, never to be seen again, Madeleine McCann style. I disagreed. My parents would look after our daughter every bit as well as my wife's parents did. My wife began to see me as a threat. She also believed, based on the unfounded accusations of her mother, that I was having an affair, and she feared that one day I would take the children away from her. It is true that my wife and I had marital issues. We hadn't had any time to ourselves for a decade. I had worked a 60, 80-hour per week for years and travelled often for work. She worked long hours herself. We now had 3 paths in front of us. 1, reconciliation, the best possible outcome. 2, amicable divorce to minimise financial and emotional destruction. 3, acrimonious divorce, or mutually assured destruction. How do you take a reconciliation or an amicable divorce and turn it into an acrimonious divorce? It's easy. Have the police block the husband and wife from speaking with each other during the divorce proceedings. This is now enshrined in law, though radically widened definitions of domestic abuse, just about anything, mandatory arrest policies and no-contact bail conditions. The CSU police repeatedly refused to vary the bail conditions to allow even mediated contact with my wife. They prevented me from seeing her when she needed my help the most, which worsened her mental distress. I requested half a dozen times, both directly and through my solicitors, to have the bail conditions amended. Eventually, after 4 weeks, a normal police officer, not a CSU officer, amended the bail conditions so that I could speak to my wife, if in the presence of a priest, for the purposes of marital reconciliation. The CSU were malicious. My solicitor contacted my wife's solicitor to inform her that the bail conditions had been changed to allow us to speak to each other for marital reconciliation. My wife contacted the police to confirm. The CSU police denied that the bail conditions had been changed, which was totally untrue. I'd always thought of the police as detectives, streetwise cops with common sense, looking at the facts to discover the truth of a situation. Now I realise that they will more closely resemble a state-funded militia that arrests people, mostly men, to fulfil the political agenda of the current feminist state, the domestic violence myth, and the industry it has created. Domestic violence, DV allegations, are the feminists' weapon of choice to achieve fatherlessness. The staggering increase in reports of domestic abuse to the police correlates neatly with the rise in government funding of DV charities between 2011 and 2015. It is these DV charities such as Women's Aid, Refuge and the for-profit NCDV that encourage women into making abuse allegations and perpetuating the myth that DV is prevalent in our society and a growing problem. Women now make allegations of domestic violence in approximately 25% of divorces. Meanwhile, the definition of domestic violence has become extremely wide and subjective, e.g. coercive and controlling behaviour, and can now include anything. Alleging domestic violence is a no-brainer for a woman. She automatically becomes exempt from a requirement for mediation prior to divorce proceedings and becomes eligible for free legal aid from the state to the pay for a divorce solicitor, subject to a means test. One barrister in the field commented to me that he does not understand why 100% of divorcing women do not make allegations of domestic violence. It just looks like that is where we are headed. Under today's state policies, particularly the positive action policy, the woman gets instant possession of the house and the children and doesn't have to share her quarters with an inconvenient spouse during divorce proceedings. He's put on the back foot by having to fight criminal allegations and homelessness at the same time as divorce proceedings and dealing with the severe emotional distress of not seeing his children. Meanwhile, he still has to turn up for work every day to keep the money coming in to pay for it all. This can break a man, both emotionally and financially. Suicide is now the #1 killer of men in the UK between the ages of 15 and 50. Men and boys account for nearly 80% of suicides. Britain has become the most anti-father, anti-family country in the world, and possibly in the history of mankind. It now has the highest rate of single mother families in the OECD countries. 26% of children live with only the mother, nearly double the OECD average of 14%. The United States comes in a close second at 24%. No historical time series data are available for the UK, but in the US, it is a historical high, rising from 8% in 1960 to 24% today. In the UK, 1/3 of children do not see their father within 3 years of a divorce, driven by women and women's groups that want to make it impossible for men to contact their children and a justice system that enables them. Contrary to the myth, this is not family breakdown or absentee dads. It is the state ripping children away from their fathers. It is state-sponsored terrorism against men and families using domestic violence as a front. Not even all the children left fatherless from men dying in 2 world wars achieved this. Acting in the best interests of the child is the argument that feminists like to use most when taking children away from their fathers. Study after study shows this argument couldn't be further from the truth. They are acting in the worst long-term interests of the child's mental health. 4 weeks after my arrest, the police charged me with common assault. I was instructed to appear in a criminal court 2 weeks later in front of a judge. Common assault is defined as follows. An assault is committed when a person intentionally or recklessly causes another to apprehend the immediate infliction of unlawful force. Apprehend means simply that they feel threatened. Physical force is perhaps a misleading phrase in that it suggests some level of force. However, any touching will suffice. If someone says they felt threatened but you didn't touch them, then that is common assault. If someone says they felt threatened and you do touch them, then it is assault and battery. Common assault is the lowest criminal offence on the books. It wasn't a criminal offence until 1988. A criminal record, however petty the crime is serious. It means almost certainly not getting a decent job again in a competitive job market. It means not being able to go on school trips with my children because I would no longer pass a DBS police check. It means being red flagged for entry into the United States, Australia, and other countries because I would have to declare a criminal record. It can also affect insurance policies and those of anyone in the household, even if not convicted. It means almost certainly not being awarded custody of the children. In my case, in spite of the extremely painful bail conditions and the abusive process, there was zero chance that I would be pressured to admit to something I did not do. I pleaded not guilty and my trial date was set. I used the opportunity to request the court amend the bail conditions to allow me to contact my wife to arrange to see the children. There were no allegations involving children and the bail conditions did not expressly prohibit me from contacting them. However, they prevented me from contacting my wife. The female district judge adamantly refused to amend the bail conditions. She insisted that I had to communicate through my wife's divorce solicitor to make requests to my wife to see our children. I stated that I already tried and that was the reason I was requesting the bail conditions be changed. The judge still refused. Her refusal forced our divorce to stay on the acrimonious track. Her refusal also deeply affected my children. My daughter was later described by her teacher as being a zombie in class. For anyone not having had the pleasure of going through an acrimonious British divorce, communicating through divorce solicitors is like sending a text message that costs £1,000 per text, but that travels at the speed of conventional post. Your solicitor writes a letter, that costs you £500, and that goes something along the lines of, my client would like to see the children this Sunday. He misses them dearly and no doubt they miss him. 1 week later, her solicitor writes a letter back, costing £500, which you pay for, if you are the breadwinner, saying something along the lines of, I have discussed this matter with my client and she does not want your client to see the children. If you tire of this and file for an application with the court, then it costs thousands of pounds each time. I was desperately trying to keep legal fees down, but now I had to pay for a divorce lawyer that was costing me about £5,000 per month, even on a managed basis. If you miss paying an invoice, they stop working. It's that simple. In the end, I would end up paying £35,000 in family court fees just trying to get access to the children, plus £20,000 in criminal defence legal fees, plus £20,000 for a flat, a total of £75,000 of unnecessary costs. The Home Office, CPS and police have become a well-oiled machine that takes avoidable divorces or amicable divorces and turns them into acrimonious divorces that result in near total destruction of the men. The women often end up as bitter basket cases and the children don't fare much better. Why is this happening? What is driving all of it? The answer lies with the Home Office. The Home Office oversees 43 police forces in the UK, nearly all of them. Theresa May headed the Home Office from 2010 to 2016. She was essentially the head of the police forces and set their priorities and policies. She is a self-proclaimed feminist. Since 2010, the Home Office have amended existing laws and drafted new ones to radically widen the definition of domestic violence, now termed domestic abuse. Rape, sexual assault, harassment, stalking and hate crimes, to the point where these categories of crime capture a broad range of common and innocuous behaviour. They are so subjective that they can be interpreted to mean whatever the police and CPS want them to mean. Coercive and controlling behaviour is now a crime. These feminist-inspired laws haven't empowered women, they've weaponised women. Zero-tolerance policies produce massive collateral damage. Families and relationships are never perfect. They can often be messy, but this does not mean that they're not good. Every seasoned company CEO and enlightened policymaker knows this, or will learn it if they don't. Corporations have a zero-tolerance policy to personal phone calls at work, but they know they don't work. States have a zero-tolerance approach to marijuana use or alcohol. They know that doesn't work. Think of the prohibition in the US. Remember those adverts from the 60s perpetuating the myth that marijuana use would lead to heroin use and then death? The same is going on now, except with feminists perpetuating the myth that familial arguments and disagreements lead to domestic violence and then to the husband killing the wife. The only logical conclusion one can draw is that the state is seeking to criminalize, emasculate, and humiliate men in line with the feminist agenda. I was fed up with this nonsense and fought back. I filed an application with the criminal court to amend the bail conditions so that they would accommodate any decision by a family court judge, such as seeing the children. The judge granted it. I then filed an application with the family court for a contact order, a child arrangement order, to direct my wife to let me see the children and to circumvent the draconian police bail conditions. My wife told the police about my application to the family court. The police witness care officer then immediately contacted the Children and Family Court Advisory Service, CAFCAS, to see what they could do. The CAFCAS case officer in our case was young, probably in her late 20s, and based in a national call centre in Coventry. She did a telephone interview with me for 20 minutes, which was the only contact I ever had with her. The relationship between the CAFCAS worker and my wife was more like a client-solicitor relationship, whereby she advised my wife on how best to formulate her allegation to remove me from the family. CAFCAS effectively is a parallel trial. It writes a report for the family court that advises the judge to what extent the father, and occasionally the mother, can see the children. They do this if there is an allegation of domestic violence, 62% of all family court contact order applications. The legal standard of evidence they use is the lowest of all, the balance of probabilities. Therefore, if the mother makes a false allegation and loses in the criminal court system, there is a very good chance that she will win the CAFCAS case. In my case, the resulting report to the family court concluded that CAFCAS cannot support the father seeing the children, in spite of absolutely no hard evidence to back this position. The evidence CAFCAS cited was from the telephone interview with my wife, which included such things as my wife's allegation that I was a bad driver and endangered the children, citing she and the children were terrified he was going to crash. I've had a clean driving record for years. And that he had difficulties in a previous relationship, but she, my wife, does not know more details. CAFCAS's international police check on me came out clean. They cited a risk of abduction because I had once taken my son camping in the Scottish Highlands without her permission. In fact, she'd booked a caravan for us to stay in at the campsite because she was worried he would die of cold. The CAFCAS case officer went on to say, all 3 children will need reassurance and stability at this time. This could be a confusing and disruptive time for them. They have been exposed to emotionally harmful behaviour and their physical safety put at risk. CAFCAS cannot support Mr. X spending time with his children. All this based on a 15-minute conversation with my wife and a 15-minute interview with me. I later learned these are boilerplate comments that CAFCAS just regurgitate in their reports. In hindsight, the CAFCAS woman had written the report before she'd even called me. The long-term damage CAFCAS and other social workers inflict on children is staggering. 1/3 of children in the UK cease to see their fathers within 3 years of divorce. CAFCAS is a causal factor in this, given the courts follow their advice in the vast majority of cases. The family court hearing took place 10 weeks after my arrest. My wife met me at the courthouse lobby and we spoke for the first time. She presented me with photos of me with 2 other women that had been taken on social occasions, e.g. a friend's wedding, and accused me of cheating on her. I tore the photos up and suggested marriage counselling. We made the proverbial deal on the courthouse steps. My wife was coming out of the fog of her mental health episode, and we were now strangely and suddenly united in a battle against the system. At the family court, there is a CAFCAS office strategically located at the front entrance to the courts. A hearing cannot start without a CAFCAS social worker knowing about it and inserting themselves into it. In my case, the social worker insisted that a study was needed on me to assess my parenting skills and whether I was a risk to the children. The hearing began. It was my barrister and solicitor, versus my wife's barrister plus the Kafka social worker in the back. The judge saw sense and told her that her services were not necessary. Thank God. The divorce application was stayed for a year. If it wasn't reactivated, then it would be struck out. I was granted access to my children. We would go on and have a highly effective marriage counselling that the police could not block us from having, and that would save our marriage. After the family court hearing, and whilst we were having marriage counselling, my wife wanted the criminal proceedings to end. She saw how the entire thing was being escalated and exaggerated by the police, Kafkas, and the CPS. It was dawning on her that each person in the police, Kafkas, and CPS were using her as a tool for their own agenda. She also realised that her own behaviour had been childish and irrational. The CPS refused to review the case in spite of my wife making 10 requests. Their refusal was in total breach of their obligation to review the case on an ongoing basis and to report reviews to the claimant. My side also requested a case review. Similarly, the police said it was out of their hands and there was nothing they could do. The CPS lied and played dirty tricks all the way. They told the court that my wife was so scared that she needed a screen to testify behind and couldn't bear to face me. My wife later told me she never said such a thing. Getting accusers to testify behind a screen in court, a common CPS tactic, wouldn't pass the due process in countries where you have a right to look your accuser in the eye, e.g. the US. The CPS delivered the prosecution bundle late, and it mysteriously did not include my wife's withdrawal statement. The police also lied and played dirty tricks all the way. The police officer in charge of the case withheld an evidence statement given by my wife to the police 2 months prior to the court date, which withdrew entirely my wife's support for the case. The police withheld this statement until the morning of the trial. The police witness care officer, who is an employee of the police and was the police contact for my wife during the entire time, strung my wife along with lies. After the family trial, when my wife and I were back on the road to recovering our marriage, my wife made 12 calls to this woman. At first, she said that the case would be dropped because my wife was no longer supporting it. Then, after 12 calls, getting closer and closer to the trial date, she said that my wife would be summoned as a witness. However, she said, "Don't worry, the case will not proceed," but my wife needed to turn up to the courthouse just to make sure she is safe. This was, of course, a total lie. On the day, the CPS did not drop the case, and there was a full trial. The court threw the case out at half-time, at the end of the CPS prosecution case, but before our defence case. The magistrate invited our side to make half-time submission of no case to answer, which we did. This is done when the evidence is so weak or non-existent that even taken at its highest is such that a properly directed jury could not properly convict upon it. The magistrates decided there was no case to answer and I was acquitted. It was dismissed on the basis that the evidence given was weak, tenuous and inconsistent. I was now free to enter my house and my wife and I were free to be together again. A feminist friend told me that in my shoes she would sue for unnecessary arrest, taking my children away from me, taking my house away from me and blocking me from speaking with my wife. Unfortunately, only the very rich or the very poor can enforce their rights under the Human Rights Act, HRA. The very poor benefit from legal aid and can get the state to fund litigation against the police and CPS for violations of the HRA. The very rich don't have money problems and can afford to take the full hit if they lose. It costs at least £20,000 in legal fees to fund a case. The upside if you win is a measly £1,000 to £10,000 awarded to you as damages. American-style exemplary damages in the order of hundreds or millions of pounds that would serve as a deterrent against future police or CPS breaches are simply not awarded in the UK. The downside if you lose is paying around £50,000 to £80,000 in legal fees incurred by the police or CPS in defending the case. This is in addition to your own legal expenses. Those are odds that 99.9% of the population cannot afford. The result is that human rights are essentially unenforceable for the middle class, and the police and CPS know they are free to breach every fundamental freedom you thought you had. Ah, you may say, It was your wife who walked into the police station and made the complaint. The police and CPS were simply doing their job. Well, no. The police didn't investigate complaints. Well, no. The police should investigate complaints, but they don't investigate. They use any complaint as a weapon to strip a man of his freedoms. Ah, you may say, justice has been done. The court has acquitted you. No, it shouldn't take £75,000 in legal fees and other costs to get to this point. If you had told me this story 3 years ago, I would have thought this was an outlier case with rogue actors. An observer might have thought that what happened to me was unique. It's not. Now I see that this has become commonplace, and it's happening to men and families all around me within 1 or 2 degrees of separation. Once I spoke about it, I learned variations of it had happened to neighbours, friends, brothers of friends, colleagues, brothers and sons of acquaintances. Many of them haven't seen their children in years, despite spending ridiculous amounts in legal fees fighting to see them, and are more or less permanently estranged from them because of their ex-wives who were encouraged to make these allegations. The entire experience was an epiphany. My marriage is now the best it has ever been, and we are both very happy. However, the state, its feminist policies, and the feminist employees who work in it tried to make my wife and I hate each other. They tried to destroy our marriage, and they tried to destroy me. They are now systematically trying to destroy other families, the foundation of society. Radical feminism has become one of the greatest threats to humanity. In the end, I decided to take the plunge and sue the London Metropolitan Police, the Met, in spite of the potential downsides. I wouldn't have been able to live with myself if I hadn't. I didn't want other families to go through what we went through. The cause of action was unnecessary arrest. I was successful. The day before the trial, the Met admitted liability to false imprisonment following an unlawful arrest. I would encourage every man to sue the police if they've been arrested under the positive action policy, which is essentially a mandatory arrest policy in the event of any allegation of domestic abuse. However, case law says arrests must be necessary. Mine wasn't. The Met had argued in their defence that their positive action policy and training they receive requires them to make arrests. I would guess 90% of domestic abuse arrests made under the positive action policy are unnecessary and are therefore unlawful. The positive action policy is a nuclear bomb that causes a chain reaction of unnecessary destruction to families and turns amicable divorces into highly destructive, acrimonious divorces. If there's one change that I could make, it's that the positive action policy be struck down as unlawful.
Thank the Lord.
Thank fuck for that. Oh, God. There was about another half hour of that, which I managed to cut out.
Yeah.
Can I just stretch my legs and then we'll do the other one?
Yeah.